1. Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 61, we're going to talk about some ethical duties that can come up in estate administration, looking in particular at a recent Idaho Supreme Court case, Kalb versus Wise, to see a very apparent circumstance in which this became an issue, but the court didn't necessarily go the way that everybody thought they were going to. Now, as always, this presentation is not intended to substitute for legal or tax advice. So what happened in Kalb versus Wise, and why are we so concerned about this Supreme Court decision? Well, the background was that there were parents who divorced, and the mother's will said everything should be divided equally between son 1 and son 2. And son 2 ended up being the personal representative, and was also represented by the family attorney who had also prepared the mother's will, and who had also represented the mother in her divorce. And as part of that prior divorce settlement, the mother's home had, as part of the property settlement, been deeded over into successive life estates between her and her divorced husband, so that upon the death of the survivor, the remainder would pass equally to son 1 and son 2. That's exactly what happened. They were both deceased, and the remainder interest ended up being vested in the sons in this life estate property from the divorce settlement. Now, what happened and what really got the attorney in trouble here is that the attorney for son 2 wrote to son 1 and sent him a quitclaim deed asking son 1 to convey his 1/2 interest to son 2. And in this, the attorney didn't counsel son 1 to get independent advice or an attorney for himself to look through this. We'll see why this was problematic here in a minute. But either way, son 1 did sign the deed and send it back. It was recorded. Then son 2 ended up as the 100% fee simple owner of the property. But lo and behold, son 1 had a conservator who ended up objecting. And this went all the way to the Supreme Court in Idaho. So, at the trial court and appellate level, those courts found that the attorney had found or had breached his duty of care to son 1. But the Idaho Supreme Court overturned this decision and found that although there's a duty of attorneys in Idaho, a duty of care to beneficiaries of the estate under testamentary instruments, the life estate deed was not itself a testamentary instrument. It was executed in accordance with the divorce settlement well prior to any of the actions or wills or anything that were part of this, and thus passed outside of the probate estate and outside of the duties of either the personal representative or the attorney representing the personal representative. But the attorney didn't quite get off scot-free, even though the attorney had no liability and no breach of duty to son 1. The Idaho Supreme Court did note there could be a breach of professional responsibility and declined to rule on that because it's not their wheelhouse, but they cited that there could have been a conflict of interest and also a breach of the duty that you have when dealing with unrepresented persons. So, within this, there are some practical considerations we can glean from the facts themselves. One is that son 1 had lifelong disabilities, and the attorney had long dealt with the family, so the attorney had to have known, 1, of these disabilities, and 2, of the existence of a conservator, and the attorney probably could have searched and found that easily or talked to son 2. And that really, all this creates the perception of taking advantage of son 1. So even though the holding is outside of the specific law and objections brought up by the conservator, this really looks like a bad action by the attorney. Because the attorney's letter, I'm gonna read this exact quote. It said exactly that son 2 desires at this time that you deed your interest in the property over to him. So if you got a letter from an attorney in the mail that just said, hey, my client desires that you give them money or property, would you necessarily respond to that and follow those instructions? And the answer is no. And the letter cited had no legal threat or anything. It just simply said, hey, son 2 desires that you, son 1, deed your interest over to him. So obviously, for son wanted to listen to that, there had to be something going on there. So it's important to be very careful when taking instructions from client. Family dynamics can really factor into estate administration, as many of you know, and it usually goes the other way in terms of fights, but when it comes to steamrolling other people, that could also be a consideration here. And it's also important to just really look at the overall estate, because more and more assets are being transferred through non-testamentary transfers such as beneficiary designations. So how far would the court go to distinguish duties that are unique to the probate estate and testamentary actions versus non-testamentary transfers like beneficiary designations? Now, it's easy for the attorney or advisor to botch a beneficiary transfer and violate this duty if they're handling any of these pieces. But when it comes time to administer the estate, the attorney represents the personal representative in their capacity as a fiduciary and not in their capacity as a beneficiary. And that's really where the waters got muddied here, is that the attorney represented the personal representative really in their individual capacity as a beneficiary and demanded that property be deeded over to son 2, and they're well outside their bounds of representation. And it's the situation here where it's more the exception than the rule that beneficiaries are represented. You can't just rely on that. And if you're sending a letter directly to a beneficiary, it's really a tacit admission that you know that beneficiary was not represented by counsel. So in any sort of situation like that, I think it's safe to throw in that, you should get independent counsel for any action that might affect your property interests or the way that the estate is going to be distributed. But long story short, there were bad facts here, but there are peppercorned throughout some unique takeaways that I think everybody should keep top of mind. Now, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of the 10th of an Hour, and I look forward to seeing you in the next one.